The station does not guarantee the results of any investments made by a listener to this program.
The Word on Wealth with Gary Quackenbush is sponsored by the Word on Wealth Radio Network.
This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary is a San Diego financial solutions attorney, protecting people like you. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future.
You're live.
Gary.
Hey, everybody. Welcome to Word on Wealth. Happy Tuesday. This is your host, Gary Quackenbush, here on the Word on Wealth. We've got lines open today. If you want to ask me questions about estate planning, wills, trust, power of attorneys, being a trustee, all that, we've got lines open, 888-344-1170. Call up and you can be part of the show. How fun would that be? 888-344-1170. I do have clients and potential clients coming in quite often, like every single day. And I have a lot of them that are telling me that they like listening to the show. And I'm always wondering what content they like. And most are saying, well, I just like what you talk about. So I would love to know specifically, what do you want to know from me, Gary Quackenbush, right here on the Word on Wealth? Let's see. So Monday we have tax. Tuesday we sometimes have mortgage. Today we don't. That's going to be me talking about estate planning. I want to talk about accounting and trustee jobs. We're just running into a lot of that here at GQ Law, the sponsor of this program. Tomorrow we're going to have Anthony Wright. He is the right guy to talk about money, and he's going to be telling us about the financial markets. The cool thing about him is it doesn't matter what's happening to the financial markets. He knows how to handle money actively, very actively. And as a fee-based financial planner, financial fiduciary, he can make money, and he just does, and he has happy clients. So that's tomorrow. And on Friday, we have a very special guest that's coming up, a trauma therapist who deals a lot with first responders and teaching things. And so super cool. That's going to be on Friday. All right. That's the rundown for the week. Okay. For the rest of the day, let's talk about a trustee's job. So when you have an estate plan, to not be confused, when I mean estate plan, I don't mean a will or a trust or life insurance or California probate code. I'm talking about an entire plan that we put together for people that deals with not only death and what happens to your property after both husband and wife dies, but we have to deal with other eventualities that are really likely. It is more likely than not, like far more likely, that one of the spouses will die before the other. Okay, the likelihood of them dying together, we need to talk about, but we think about that more than anything. It's like, okay, so when husband and wife die, then the property is going to do this and that and the other. But we don't think about, well, what if dad dies first? What if mom dies first? Okay, husband dies first, wife dies first. What if we're not old when we die? What if wife dies young? And the possibility that husband will remarry. What about if husband dies young? What's the possibility of wife remarrying? What's going to happen with that? And it really depends on all the property, like what you have and what you want to do with your stuff. So a lot of the estate planning process is trying to plan on these different eventualities without thinking about them too hard. And I'm not going to really drag you through it too much, but I'm going to ask a lot of really important questions to figure out what you really need and what you really want. And I'm going to help you make that decision. So with the other part of this whole thing is, what if you don't die? And I don't mean forever. We're all going to die. But what if you don't die? What if you became incapacitated? And by that, I mean to the point where you can't manage or handle your money. And the way that looks, for a lot of us know how that looks, because we've dealt with it. And with my mom, it got to be where she had a lot of subscriptions. And I know some of these things, it's almost like a funny thing to talk about, like, oh, it's an old person with blue hair or purple hair, and they've got magazine subscriptions for the next 20 years. And the reason we say things like that is because they're actually true. Side note here, the hair thing, I have a really good friend. She's recently passed away, but she was a hairdresser for a long time. I mean, very sophisticated, carries her Louis Vuitton bag, does hairstyling for people, and people paid her hundreds and hundreds of dollars to do their hair. And the old thing with the blue and the blue hair and the purple hair was because of bad dyes that didn't go well with gray hair. So she thought it was really funny because way back when people were just trying to make their hair not look so white or so gray, they're trying to make the color look more consistent, and the dyes didn't do a good job. And so they made it a little bit of a blue tinge. Well, now some people just do it blue or purple, and I don't care what age they are. So it's very interesting. Anyway, one of the other things about when people get older is it's like, oh, grandma's got subscriptions out for the next 10 years. Well, the subscription thing is such a big scam. It really annoyed me because it is true. What would happen is my mom would buy a subscription, like to Ranger Rick magazine or something, and she would buy it for one of the grandkids, like maybe the oldest one, Ezra. And so then she would get the renewal thing. And you know how magazine subscriptions work. You have a year subscription. Let's say you get it in January. Well, in like March, they're sending you a thing saying, last issue coming up in December. Last issue, warning, if you don't renew now, the last issue is going to be here. And next thing you know, so, send us a check for X amount of money. And they're not looking at the little small writing where it says last issue, huge letters. And then underneath it says, as of December of this year, which is 11 months, 10 months away. And so my mom would write another check. And we literally had one of my grandchildren, which would be my mom's great grandchild, had a subscription to like the Ranger Rick magazine that was going to go on for like 5 or 6 years. It was crazy. And they would do it again. They'd send her another thing. Got to renew. We'll multiply that by multiple grandchildren. And if she could remember who they were, then she would get them subscriptions. And it was really sad. So my sister ended up doing a lot of work and going and unraveling a lot of things. And literally it was canceling subscriptions and figuring out who was who, what subscription was what. So that happens to people. Okay. It happened to my mom, and it was sad. Kind of annoyed me that was what the magazine companies do. And they tend to be abusive. And my mom got to the point where it wasn't just the magazines. It got to be other things, like didn't realize what her bank balance was, and she would write checks and didn't realize that she'd written a check before and all that. Well, a lot of us get to that point, and part of the estate planning process is we want to provide for that eventuality. We want to make sure that your money is in a living trust and that you have a successor trustee named that you're going to trust that will do a good job and take care of you. And that could be, in my mom's case, that would have been my oldest sister, super responsible, super, loving. She took care of my mom for all the way to the very, very end. And that's what my mom, that's who she had taken care of, which is great. A lot of people don't have that opportunity. They don't set up a trust. They just kind of let things go. They don't want to talk about it. We got to talk about it with our parents. You have to get your own estate plan so that doesn't happen. There's not problems that end up with your kiddos and dealing with it. All right, I'm going to talk when we get back a little bit about successor trustee jobs, doing their job, and how that works right here on The Word on Wealth.
You've got questions. We've got answers. This is The Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is Faith-Based Investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
Gary, our listeners are asking about trust disputes
disputes.
and whether or not they'll actually get the inheritance
They're entitled
expecting.
to. I think that's a scary thing for most people because they feel like, you know, if I ask my successor trustee, hey, where's my inheritance?
money?
You know, you kind of feel like, oh my gosh, I'm being like rude or whatever, inconsiderate. But I'm telling you, if time goes on, if it's been like 60
1, 2,
days,
3.
90 days, you know, 120 days, that's too long to have heard nothing. You're supposed to hear fairly soon, like within a couple of months after someone's passed, you should be hearing from that successor trustee. And if you're not, I think there's an issue we need to address. So it's not like we're going to go screaming in there and filing lawsuits. We kind of use gentle nudges like, hey, do you know what you're doing? Successor trustee, we kind of want to help you do your job, and we help beneficiaries kind of get things straightened out.
Call or click to request your free initial consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group. From single-family attached homes to luxury high-value waterfront properties to apartment buildings, Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 0.
Talk with a member of the team. Call Gary at 855-500-TRUST. GQLaw.com.
.com. And here we are back with just me and you. 888-344-1170. Call me. Seriously. You feeling lonely? Call me. Let's talk about it. Let's talk about your estate plan. I know it sounds like when I talk about this, it's like, gee, are you feeling lonely? No, I'm not. I'm good. I got lots to do. Tonight,
But if I'm feeling lonely, Gary, all I got to do, I'm literally a button push away from bringing in my good friend Gary Quackenbush to boost my spirits.
You know, that's a good thing. That's a good thing. I know we have kind of like this therapy thing going on, huh? Geez. Hey, tonight, folks, Andrea K show.
Oh, you're like on Andrea K or something.
I'm on like Andrea K, and it just happens to be that Noah, the man in my ear and yours, is the producer of that show. So that's tonight from 6 to 8. I will be on at 7. So don't hesitate to basically log in at 6, and I will be on at 7. And gee, the stuff we talk about, you know, Hollywood, of course, it makes the news and it makes it sound like everybody is messed up. But tonight we're going to talk about an estate that everybody knows about that was messed up. And it's frustrating. I'm telling you. I had a really nice couple that came in today. And I always ask, like, so why are you here? And I don't say it that way. I say, why are you here? Do you want to talk about death and dying today? And they say, that's funny. and they laugh, and we talk about death and dying because that's my job. I'm not that I'm like the Grim Reaper. It's just that I'm the guy that says, let's get it organized. Well, I was told today that the reason they want to get an estate plan, a living trust, etc., is because their parents had a living trust, estate plan, well done, etc., by me, and that after mom passed away, and this I loved, she said it was so smooth, it was seamless, the transfers worked great. I want the same thing. Give me what my mom had. That was pretty cool. So I like that. So if you want to come in and, ask those questions, or you want the same thing that we provide for lots of clients, it's 855-500-TRUST. Another thing I want you to do too is to help you understand a little bit more about estate planning. Information is good. I have a book on my website, and the book is called Living Trust Basics. So you go to my website, which is gqlaw.com. Imagine that, GQ, kind of like my initials, Gary Quackenbush, gqlaw.com. And on each page on the side, depends on whether you're on a tablet or a cell phone or a computer, but you click on this book cover, they're free materials, click on a book cover, and you put in your name, email, and it sends you a PDF of a book called Living Trust Basics. It's an outline that I've created over a gajillion years of doing this. I've distributed that outline all over the state of California, hundreds and hundreds of times, as I have done seminars on living trusts and estate plans. And so it's helpful enough that you don't have to read forever. It's only 20 pages long. It's kind of in a summarized format. And most of my people look at it and go, this is cool. I like it. So get that book. That'll help you, and you can pass it along. I mean, I would love better that you just tell somebody, yeah, go get it from Gary's website and they can put in the information. But if you forwarded the PDF to them, I'm okay with that. They just won't get any follow-up information. So just depends on what you want, but it's a good book. It's been up there for a while. It is still free, and we're in May. So happy day after May Day. And yeah, it's still free. So it's going to be Living Trust Basics. All right. Being a successor trustee, we've talked about that job before and what it takes. So if you are listening and you are named in your parents' trust, or you're going to name someone in your trust to be a successor trustee, I wanted to talk a little bit about the job. The job of a successor trustee is to carry on what the trustee did. So terminology here. The trustee is the first person that manages the money in the trust. So the trustee is going to be you. So when you set up your trust, you're going to be the trustee. If you're married, it'll be you and your spouse that'll be the trustees. Once neither of you can function as a trustee, then the successor trustee's job starts. The reason that's important is because the trust is usually put together to say that as long as the creator of this trust, who just happens to be, or who is also the trustee, as long as the trustee is still in charge, the trust is revocable. It can be amended or changed, and it can be amended or changed by the creator of the trust, which would be you. Also, the manager of the trust can supervise that and accept the terms of the new or amended or changed trust. That's because you are that successor, or you're that trustee. When a trustee is functioning and there's a successor trustee, that means the trust is going to be irrevocable, which means unchangeable, not deletable. You can't mess with it. The good news about that is if it's your trust that you set up and you wanted to make sure that certain things happen, like a certain amount of money to this kid has to behave in a certain way, this kid got to be doing this is going to be used for that. Once you've laid that out in your trust, you can change that yourself. You can change it whenever you want. But once you pass away, or once you become incapacitated and now your successor trustee is stepped in place, the trust is no longer changeable. So what that means is even if you are, incapacitated, the successor trustee that takes over now, they can't look at it and go, well, dad doesn't know what's going on. Neither does mom. And I think I deserve most all of the money because I'm taking care of mom and dad. So I'm going to go and I'm going to change this trust. It doesn't work that way. It doesn't happen that way, because if you do, it's actually illegal. because you can't, as the successor trustee, you cannot legally change the terms of the trust. And who's going to be enforcing it? The other beneficiaries. So it might be your brothers and sisters. Okay. If you're an only child and you decide to change the terms of the trust, the only person you're hurting is yourself or potentially your parent that needs that money. So what is the trustee's job? Well, while the parents are still alive, it is a massive job, because if you're acting as the successor trustee and you have living parents, you have a fiduciary duty, which is a responsibility to act in the best interest of the beneficiaries. As a fiduciary, even though you're not a professional, even though you're just a person, right? You are held to the standard of a professional fiduciary. That means if you don't act in the best interest of mom and dad, then you could be surcharged. That means your estate can be, the amount of money you eventually inherit, you could lose that because it's got to take care of, something, maybe you fouled something up. So don't do that to your parents. And also your siblings are going to be watching to see if you're spending the money on yourself. Okay. So as the successor trustee, then your job is to take care of parents. Your job is to watch the money. And my recommendation is the day that you take over as successor trustee, or when you suddenly realize, whoa, mom and dad cannot handle their money and they have turned the checkbook and the pen over to me, and I'm even the signature on the bank. From that day on, my recommendation, every receipt, every bank statement, catalog it, put it in order, because someday, eventually, whether the trust requires it or not, you're going to have to provide an accounting to the other beneficiaries. And as time goes on, 6 months, 9 months, 12 months, 18 months, 24 months, as time goes on, it gets more and more complicated. And you got to keep track of the money because it's not yours. It belongs to the beneficiaries. If you're one of the beneficiaries, okay, part of it is yours, but not all of it. So you account for everything. What does that mean? You have to use it through Quicken, if you know how to use Quicken or QuickBooks or something like that, or an Excel spreadsheet or a Google spreadsheet or something where everything you spend, you track it. You can do it through a checkbook or whatever, but you've got to track everything. That's just really important, because what will happen is later on, if somebody challenges it and says, hey, you're a terrible trustee, what'd you do with that money? I want an accounting from day one. Well, even if the trust says you're not required to account, a court can say, yes, I want you to account because we think there's something funny that went on because your siblings are screaming about doing something funny. So you have to go back and account for your whole tenure. Now, if it's been 2 or 3 or 4 or 5 years, it may be really difficult to do. And you may see some mistakes along the way or not, but just keep it up as you go. This isn't your money. It's not your tax return. It's not your estate. This is mom and dad's money. You as fiduciary are supposed to be managing it. So just be super, super careful. Okay. So with that job, and by the way, if you have questions on it and you want me to talk to you directly off the air, you can call my office number, which is 855-500-TRUST. And what we can talk about is what your job is, how have you been doing your job, and what you need to do to complete it, especially if mom and dad have passed away and you're the one handling the money. There's some things you got to be careful of. The thing that happens with being a successor trustee is, like I always say, my mom, when we were messing around and slamming doors and racing around the house and doing things, my mom would always say, it's all fun and games until someone loses an eye. That's her saying. And then lo and behold, I slammed the French door on my brother and he stopped it with his elbow. And this is an old house that was 100 years old at the time, and they didn't use safety glass. And that glass broke and it cut my brother's elbow open. And he, even in his mid-60s, has a nasty scar from where Gary, slammed the door on brother. And you don't think I was punished for that? You guys, that was a long time ago. Yeah, we punished kids for doing stupid things. So it was a big deal. But the idea is, like in accounting with the trustee, is it's all fun and games until someone loses an eye. Other words translated, it's all fun and games. Everything's casual until someone says, hey, what'd you do with my money? And then they can go to court and get it enforced. And if you mess with their money, you can get surcharged, like a fine that comes out of your share. So they have a right to know what's going on. Even if the trust says the trustee has no obligation to account to the beneficiaries, That's not really going to be true because if the court figures there's some reason to believe that you should be doing accounting, they're going to require you to do it. And sometimes going back and doing an accounting for the last year or 2 or 3 or 4 or 5 is really brutal. And it's a lot of work. And if you've lost statements, you're going to be going to the bank, you're going to be downloading things, you're going to be paying all this money to do an accounting. So trustee, account for your job. Just keep track of it. And keep track of how many hours you do things. Keep a timesheet, just like it was your job. And you clock in, clock out. Keep a timesheet. How many hours today? How many minutes today? Because in 6 months, 9 months, 12 months, 18 months from now, if somebody's challenging you and saying, yeah, you did a bad job, and you decide you want to get paid for the job because you can be paid as successor trustee, it's written in the trust. Every trust I've ever written, every trust I've ever read, all say successor trustee can be paid a reasonable fee. And reasonable fees are typically about 1% of the corpus of whatever's in that trust. So it could be good money, but you're going to have to account for it if somebody's going to fight you on it. So you just keep track. You're trying to cover your tracks and make sure that everything's accounted for. That's the idea of the accounting. So that's the idea of the successor trustee. I want to come and talk about what if the trustee, like your brother or sister, is not doing a good job? What if they're doing a lousy job? How do we figure that out? How do we do something about it? What if I'm not told what's going on? And these are things I really want you to know so that we can help you get this resolved. 855-500-TRUST is my number. 855-500-TRUST. We'll be back in just a moment here on The Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com. 855-500-TRUST. Ask for the legal help you need. Call Gary and the team at GQ Law, 855-500-TRUST, or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500-TRUST.
You're live.
Trust me, 855-500-TRUST. Yeah. So to be part of the show, it's 888-344-1170. What's the trustee's job? So these are what I call the tough questions because you don't like to ask these. Mom passed away 5 years ago. Dad passed away a year ago. You were invited to the funeral and you were told everything is all thumbs up, gonna take care of it. Everything's gonna be cool. Don't worry about it. I got this. And that was from Big Sister. And now a year later, you haven't heard anything. In fact, when you text Big Sister, she doesn't even respond. Or maybe she sends you a Christmas greeting, but that's all. And you're saying, what happened to mom's stuff? All right. So what happened to mom's stuff? We find out, this is a true story. We find out a year after the fact that mom's stuff is all transferred to Big Sister. And when you find it out, you go, I thought mom was supposed to give stuff to everybody. And Big Sister says, yeah, well, she changed her mind. So Big Sister, also the trustee, decides that she was the person that was going to inherit that house. And she, as the successor trustee, deeded the house to herself. Now you ask Gary, that's ridiculous. How could she do that? Well, as a successor trustee, she has the authority to do that. Now, whether it's legal or not, or whether it's legitimate, or whether she can be sued for it, that's a different story. But she can do it. So that's the thing with the trust. When you put somebody in charge of that trust, the successor trustee, after you die, that successor trustee steps into your shoes and they can do the transfer. So we don't need mom's signature on the deed. We don't need dad's signature on the deed. We simply need the signature of the successor trustee. So what if the successor trustee decides to put to just take possession of the property? Because honestly, she said, no, mom told me, you took care of me, honey. You've been with me for the last 3 years and nobody else has come to take care. So you get the house. So she transferred it. Now, if you look at the trust says equal shares to all 3 children. But now the house is in the name of sister. What the heck do you do? Well, first of all, don't wait that long. So if you do, and now you find out it's in sister's name, what you do is you need to go and get the help of the probate court. If you think you can write a letter to sister and say, hey, sis, love you. Glad you took care of mom. That was super cool. I wish you would have let me come over to the house and visit a little bit more. You were a little aggressive about that and kind of shut me out, but I still love you. And where's my inheritance? And she says, interesting. You didn't get any inheritance. Mom gave it all to me because I took care of mom all the way to the end of her life. And you say, prove it. And what is she going to do? She's going to have to prove it to you. So the way you get the probate court involved is you would go to the probate court, and the idea of the petition is I'm going to the judge and saying, hey, judge, mom died a year or so ago, dad died 5 years ago, whatever. And I never got any notification of the trust. I didn't get a notification that said that here's a copy of the terms of the trust. I have a right to object to the trust. I never got that, judge. And I would like to know what the trust says. And while you're at it, I would like to know what was in that trust and where the money is now. And that's called a demand for accounting. It's also, you're trying to compel the trustee to do their job on a petition that says, I believe there's a trust, but nobody's given it to me. So you're having to assume there is no trust. So you're going to probate court to try to get the judge to give you that trust. And the judge will do it. The judge will say, bring the trustee in, whoever is supposed to be the successor trustee, and they will bring him into court and say, I'm ordering you to give a copy of that trust to your siblings. Now, even if all the kids were disinherited. So let's say, first of all, we know that, let's say it has 3 kids and the successor trustee child now owns the house and she thinks she's in good stead because mom said before she died, you can have the house. So she transferred it to herself. So she thinks she's doing right. Well, the documents don't agree with her. So that's not going to be the case. It's not going to hold up. Okay. Then the second thing is, you could ask her like, well, what makes you, believe you can have this house? Well, if she starts to try to sell it or something, you're going to have to file a lawsuit really quick and file a, file a claim. It's called a lis pendens. and it makes it so she can't sell the property if there's a dispute as to who owns it. But what you're trying to do is get her to provide an accounting to show where the money is and where it went and all that stuff. Now, when you're with the judge is going to tell her to give you an accounting, give you a copy of the trust, and then you can look at it. Now, what happens is, going back to like who gets the notification. If the trust says in there, I give all my money to my oldest daughter, and I specifically disinherit my next two children, who's entitled to get a copy of the trust? They've been specifically disinherited. The answer is everybody, because the one daughter gets it because she's a beneficiary and a daughter. The second and the third kids get it because they are heirs. They're children also. Okay, so they get notification. So when somebody gets disinherited, it's not like it's a secret. They get to know, and they get to go and challenge the trust if they want to, or at least question why it happened and see whether they wanted to do something, to fight like a no contest clause or something like that. But they get to know that. And anybody that's listed in that property, if you list and say, oh yeah, my ex-wife, she's not going to get anything from me. I want to specifically make sure she gets nothing. And I make sure my neighbor's, been kind of asking too many questions. I want to specifically disinherit him and say, my neighbor doesn't get any money. My neighbor, John. Well, once you start naming people in your trust saying that person gets nothing, that person gets nothing, and they're non-family members, they get a copy of the trust because they're named specifically in the trust. So if you're trying to get rid of people, disinherit and make sure they don't get anything, just don't put them in the trust. But if they're your children, they're going to be notified. Legally, they're going to be notified. So in the scenario we're talking about where sister now has, successor trustee sister now owns the property and she's just sitting back, treating it as her own. She's, wanting to go and get financing. And probably by this time, and we had a case where she had already gotten a loan, pulled money out of the house, and she was spending it and having a good time, and because that's what she, said she was told by mom. So now she has the house and she's, got a loan on it. Well, you've waited so long that now you got to try and unravel all that stuff. And what you're going to show is that that house was not legitimately or legally transferred to her because it was done in violation of the terms of the trust. And as long as she hasn't got rid of the house and gotten rid of the money by now, then the courts will likely turn it over and make her, somehow pay you, whether it's by selling the house or financing the house and buying it from you or whatever. But understand the trustee can do things that are wrong because they have the checkbook. That doesn't mean they should. It just means they can. So don't let the trustee get themselves in trouble by doing silly things and spending the money on their own. Make sure you stay on top of things. And the court, the probate code allows that if you request an accounting and say, hey, sister, I want an accounting, they've got to give you an accounting. And if they don't, you can go to court and compel one. And sometimes that's necessary just to stay on top of it. Because when you wait too long, it's really a pain. Now, the other thing you can do is if the trustee, like you think the trustee is like sitting on the money and then they're doing wrong things with it and you think you can prove it, then you can actually go to the probate court and ask the judge to suspend the trustee. Basically say, trustee, you can't do your job anymore. You're kicked out, you're suspended, and they can put in a temporary trustee or they can put in a permanent new trustee, and that could be the one that's petitioning. So if it's your sister, she's not doing a good job, and she won't release her job as trustee, you can go in and get her kicked out and maybe make it so that you can do the job yourself. So that's always a possibility. Okay. The other thing that you can do is instead of trying to get yourself appointed is you could find a private professional fiduciary that looks at once you find out what's in the estate and you think where the accounts are, you think what's going on and there's some money involved. Sometimes you can get a private professional fiduciary, somebody that's a professional that will actually be willing to step up. So then your petition is not to put yourself in as the trustee, it's to put in a professional. And sometimes judges like that better than having a fighting or contesting child step in. So those are all possibilities. Okay. Another thing I do want to talk about is, and if you do have questions with this, make sure you give me a call, 855-500-TRUST. And then the next thing is, what if you had a situation where you think there was something wrong with the trust, like it got changed? So I want to talk about a couple of scenarios like that too. That's kind of weird. All this stuff
30
gets
seconds.
resolved if you, all this stuff can get resolved if you get the trust and everything done correctly. So that's really, the big thing to be concerned about is making sure your trust and your estate plan is put together properly. Because if it is, a lot of these things just don't happen. And then you want to get a trustee that you believe you can trust